All right, good afternoon, everyone. I think we have everyone on video except for the city of Racine. I'm assuming that Attorney Lutney is going to be appearing by video, so I'll give him a chance to get his video going. And there he is, I see him. All right, and let's go around and make sure the video all works and the audio. Attorney Nudo, can you hear me?
Yes, I can hear you, Your Honor.
Thank you. Mr. Yandel, can you hear me?
I can.
Attorney Terry, can you hear me?
I can. Good afternoon, Your Honor.
Good afternoon. And Attorney Lutney, can you hear me?
Yes, sir. Thank you, Your Honor.
Okay, and you have, is that Administrator Bowersox with you?
No, that is Deputy City Attorney Jennifer Williams.
I can't see. It's really fuzzy, so I apologize. I can't make you out very well. I can see there's two people there and that's about it, but that's fine for purposes of this hearing. Let's call the case then. As soon as we're not going to call the case until my clerk gets in. So I'll give her a moment to have her audio spool up. Jerry, can you hear me?
Yes, I can. Thank you.
Okay, let's call the case then. It's David Yandel versus City of Racine and Dottie K. Bowersox as defendants. It's case 20CV1045. May I have appearances, please?
Good afternoon, Your Honor. Attorney Anthony Newton and Attorney Todd Terry on behalf of the plaintiff. Also present is the plaintiff, David Yandel, and his wife, co-owner of Harbor Park Fitness via Zoom.
Good afternoon to all of you again.
Your Honor, defendants appear by City Attorney Scott Letney and Deputy City Attorney
Can't hear.
Jennifer Williams.
Can't hear. Scott Letney.
Yeah, Attorney Letney, we're going to have to work on your, that was an appearance by Attorney Letney. I couldn't hear the rest. It was a bit garbled. So let's work on that audio before we get into the main arguments here. Attorney Letney, do you have a microphone on that council table?
It's on the console and it's on.
He's got to get closer.
Yes, can you get closer to the microphone? And I'll give you a chance to get all your materials in place. We've got all afternoon, so don't worry about that. While we're doing that, I'm sure the parties have seen that, but I just wanted to let everyone know that we are on YouTube Live and meeting our public sittings requirement via YouTube on the court link. No one else is in my courtroom. My clerk is in her office. My court reporter, whose head you see there, is socially distancing at her house. Okay, Attorney Letney, let's give your audio another shot here.
Well, Judge, I saw you talking, but I didn't hear you talking.
You're all garbled, though. I'm glad you can hear me loud and clear, but I really want to be able to hear what you guys have to say today. So let's keep working on this until we get no garble from your microphone setup.
I'm not sure what the answer is, Judge. We use this room in this setup for common council meetings and committee meetings, and it always seems to work.
Well, that's going okay, as long as you, if you really use those chest muscles and project your voice, I think that'll work.
I will, Judge.
So let's get.
And I would note, okay, Judge, I was just going to say the first few words out of your mouth each time you speak, we don't hear. So it may be something that it just takes the system a second to realize someone is talking.
That's strange. I've used this particular computer on Zoom for the last couple months. I've never had an audio problem. I'm questioning whether it's the equipment on your end, but you tell me that you use yours all the time too. And that works fine. But we got to sort this out before we get into the weeds here on these issues. So am I still, as I talk, as it comes through, the first couple of words missing?
I think the audio is just a little delayed, but I think it's complete, Judge. That's probably what's going on.
All right, well, let's take note of that and pause for each other so that we give each other a second for the audio to catch up. so we don't walk all over each other, and so that my court reporter doesn't come after me after this hearing with some type of sharp implement for making a horrible record, which is her job. So, okay, this is Mr. Yandel's motion. He's looking for a temporary injunction to stop the city, and in particular Administrator Bowersox, from, well, at least enforcing her last order, maybe enforcing her current order, and enforcing in the future. And I understand it at its heart. This is a declaratory judgment action that's really seeking this court to interpret Administrator Bowersox's powers under Wisconsin Statute 252.03. As part of that, obviously, she's issued orders under that statute, one of which is the forward Racine order that Racine, City of Racine, is currently under the force of. She had a previous order that was on May 13th of 2020. And at that time, after that order was placed, is when Mr. Yandel filed his case. Since then, the order changed. And at least right out of the gate, the city and Administrator Bowersox are questioning whether you have standing to ask for this temporary injunction, and whether certainly the question whether I should grant it, and we'll get into that. But right out of the gate, let's talk about the procedural position of your case. And I look to you, Attorney Nudo or Attorney Terry.
Thank you, Your Honor. I believe the matter is well briefed, and there are substantial facts on the record through the affidavits. However, there are obviously several issues that I would like to talk through and to the main points. There are two definite main points that I would like to talk to. Number one, the impact of the order on the business itself. And number two, the limitations of the local health officer's power under 145.06 of the Administrative Code. I'd like to take the latter first. 145.06 of the Administrative Code was created under the authority of Chapter 252, specifically Chapter 252.02 sub 4 of the statutes is the enabling statute for DHS to make the rules under 145.06. In a vacuum, 252.03 is unconstitutional. 252.03 is the local parallel to 252.02, which, as this court well knows, the Supreme Court discussed at great lengths in its recent decision, Legislature v. Palm. And in that case, the Supreme Court held that in and of itself, 252.02 with no administrative rules is unconstitutional. So if 252.02 is held in a vacuum with no administrative rules, it can't be, the powers under there can't be utilized by the secretary as was tried during Emergency Order 28. What the Supreme Court is telling us is that under 252.02, administrative rules has to take place, administrative rulemaking. Administrative rulemaking did actually take place for 252.03, and that's what we have under 145.06. 252.03 would be just as unconstitutional without any limitations given to it through administrative rulemaking. Its purported powers too broad and not defined.
Attorney Nudo.
Yes.
Where under DHS 145.06 does Administrator Bowersox have the power to issue the order that she did? I read DHS 145.06 sub 4 says authority to control communicable diseases. She has the right, as I read it, to issue a directive under that. If people don't follow it and ignore it, she has the right to go to court and have a court order it. I'm not aware of any court order that Administrator Bowersox has obtained. And I'm not aware of any directive that she's issued. All I'm aware of are orders that she's issued, citing explicitly to her powers under 252.03. Am I missing something?
No, Your Honor, you're not. And I believe that her power is limited under 145.06, and I don't believe this order is compliant with 145.06. Ms. Bowersox, if she is, which I believe she is, concerned about communicable diseases, in this case, COVID-19, she has the authority under 145.06 to go on an individual basis, not on a broad general basis such as this order. This order is not legal under the Administrative Code 145.06.
Well, let's talk about that because under Chapter 252, Chapter 252 isn't just what we're looking at. We're focused on 252.02 and 03 in this case, certainly, but local health officials such as Administrator Bowersox certainly have powers under 252.06 to isolate and quarantine individuals. Is that correct, Attorney Nudo?
I'm sorry, 252.06 or?
Yes. Have you reviewed the isolation and quarantine portion of the chapter? That's okay. That's okay. I have. And at least at my initial reading, and certainly Attorney Letney is going to get a chance to address all this at his shop, but I'm got you guys first, so I want to try to get my arms around all of this. 252, Chapter 252 has what would be very general seeming powers, if they're interpreted as such. Under 252.03, sub 1 and sub 2, they appear to be general powers or general powers which could lead to general orders of general applicability. Is that what you believe Administrator Bowersox has used those statutes for?
That's what I believe.
General order of general applicability?
I believe it is a general order of general applicability because it does apply to the entire population of the city of Racine, not only to the entire population of residents, but of those that even visit and work in Racine.
Okay, are you aware that in Chapter 252, there is a specific provision in regards to tuberculosis, infectious tuberculosis control?
Yes, I am.
And in my reading of that, it's, let me just page through here. Okay, 252.07. Under that provision, Administrator Bowersox has the power to isolate individuals with or quarantine or commit them really as well to a hospital. She has that power to do that for individuals infected with tuberculosis. And there's a due process safeguard. She can issue an order under that statute, but within 72 hours, excluding Sundays and holidays, she has to petition the court and allow that person to have due process heard in a circuit court. Are you aware of that?
Yes, I am, Your Honor.
Do you believe that Administrator Bowersox's execution of her, at least her May 13th, 2020 order and her forward Racine order, if she has the powers that she claims she does, is that power so vast that it sweeps away the necessity for any of these other statutes? Because I looked in 252.03 and I don't see any due process safeguards for individuals that are swept up in that, including individuals swept up that might have tuberculosis or individuals that might have any other infectious disease.
Your Honor, I believe you are correct, and that actually goes to the constitutionality of it, that it's too broad, too vast. The legislature did not make any hard and fast rules, as you have cited in the 252.07 tuberculosis. That has a method for due process where individuals who are affected by an order from Ms. Bowersox has the ability to proceed with their due process rights under the Wisconsin Constitution. She did not provide that in this order, nor does 252.03 provide that to any individual.
So let me read DHS 145.06 sub 4. Certainly there's people in the courtroom on YouTube that are hearing all these numbers and they're pulling their hair out. I want to read what this one says. it says authority to control communicable diseases. When it comes to the attention of an official empowered under section 250.02 sub 1, 250.04 sub 1, or 252.02 sub 4 and 6 stats, or under section 252.03 sub 1 and sub 2 stats, that a person is known to have or is suspected of having a contagious medical condition which poses a threat to others, the official may direct that person to comply with any of the following, singly or in combination as appropriate. If Administrator Bowersox has this vast power under 252.03 sub 1 and sub 2, what's the necessity for this DHS 145? I mean, she could just order that under 252.1 and 2, couldn't she?
If that she believes that, but no, it's not the case. You're absolutely correct. And what's important to note is that any conflicting order that that Ms. Bowersox would have is superseded by these rules pursuant to 252.02 sub 4. Specifically, rules that are promulgated and orders that are issued under this subsection supersede conflicting or less stringent local regulations, orders, or ordinances. Ms. Bowersox's order certainly conflicts with the rules promulgated by the department under 145.06 sub 4 specifically. So this 145.06 absolutely controls and supersedes any authority that Ms. Bowersox believes she has under 252.03.
Okay, please proceed. Thank you.
Thank you, Your Honor. As I stated previously, the local health officer, Ms. Bowersox, in this particular instance for the city of Racine, can direct individuals under 145.06, but it is a specific written directive, and the only way for enforcement is for a court, such as this court, to issue an order. That is the only method of enforcement under 145.06. The local health officer cannot make the broad orders to the general populations as she did under her current order. You'll hear from opposing counsel that this issue is moot because Ms. Bowersox changed the order. It is not. This issue is not moot. This is one continuous order. And the defendants in their own brief say this is a moving and fluid situation. The coronavirus situation is moving and fluid, and so is the order that Ms. Bowersox issued. So this is not a new order. This is a continuing order. Under the defendant's theory, this issue would become moot if Ms. Bowersox slightly changes this existing order, the forward Racine order. It's
now,
just, yes.
Right. Now, if I grant your TRO and ultimately your temporary, your declaratory judgment request, how, if at all, does that affect the receipt? Well, let me put it this way. In the brief of the city seems to take issue with or make some argument that this court should be swayed by the end result. At least that's how I took it. I'll let them clean up the record when it's their turn. But I got the sense from their brief that they thought that because this is so dire, because there aren't many tools at the city's disposal, that if I were to grant your request, either temporarily or permanently, that they're left without anything to fight the pandemic. And because it is such a public health concern, at least in their argument, that perhaps I should be swayed by the end result and maybe not apply the law as I see it. Did you take that brief to be arguing that? And if so, what's your response?
Yes, Your Honor. The Constitution, as we well know, was created in a matter of chaos. The pandemic that has occurred in these last several months has been chaotic. To be sure, I don't believe any person has seen the likes of this literally in the last 100 years. However, just because there is chaos and there are issues doesn't nullify the Constitution. The means are not to an end. The law still must be followed. The Constitution still must be followed. And I disagree that with the city's position that they would be unable and unarmed to combat any potential transmission of COVID-19. They absolutely do under 145.06 of the administrative code. That is the procedure that this state has laid out, the constitutional procedure that it has laid out. So to that end, Your Honor, I wholeheartedly disagree with the defendants on that the ends are, it's a means to an end. We have to follow the law in this situation, especially in this time of desperate desire need. Your Honor, the plaintiff, the other issue that you will hear from the defendants is saying that under the requirements of the temporary restraining order, that the plaintiff has to show imminent and irreparable harm, and that my client has not shown irreparable harm. I, again, wholeheartedly disagree. There is irreparable harm currently right now, and it's under imminent threat of closure. My client's business, as Your Honor has likely seen in the affidavit, has been declining, and his business will fail if this order from Ms. Bowersox, it remains in effect and is enforceable.
Well, tell me a little bit about how his gym is operating currently. Under the forward restraining order, gyms are allowed to open. They've got requirements like every other business, but how is the strictures of the forward restraining order, how are they affecting your client's business?
Your Honor, it's drastically affecting my client's business on several fronts. Number one, there is a limited capacity to any members coming in. And what typically happens is in a non-coronavirus area, an issue without this order, there would be back-to-back classes. So there are classes for this fitness center starting at 5:30 in the morning, and then 6:30 in the morning, and then 7:30 in the morning. Well, those have to be spaced well apart now to ensure that not more than 10 people are in the fitness center at any given time, because typically there will be some overlap. So there is a loss of revenue, just that in and of itself. There is a difficulty in obtaining new customers, because there is obviously attrition in fitness centers, and obtaining new customers is a major part of the business for my client. And I'm not sure if Your Honor would take testimony, but my clients are willing to testify and to expand on the affidavit and the actual issues that they're facing there.
Attorney Letney, any objection to having one of them sworn in to offer testimony today?
I see that no need for it, Judge. They have an affidavit. They should have been able to say whatever it is they have to say to you.
Attorney Nudo, is there something that isn't in the affidavit that you want to add to the record?
There is. It's actually through Corian Yandel, Dave's wife, who is also an owner of the business, who it goes directly to the heart of the operation and actually the attraction of new clients and what it takes to get a new client, and the time that it takes through advertising and marketing and other items to replenish any of this lost business.
Okay, on that offer of proof, I'll swear her in, and obviously Attorney Letney is going to have a chance to cross her. So is that still something you want to do?
Yes, Your Honor, and if it would be fine, my co-counsel Todd Terry would have the direct on this.
Absolutely. Okay, ma'am, I want you to come forward. I'm sorry, Corian Yandel. It's you, sir. I apologize. Or is it, who's Corian? It's you. Okay.
Corian is the wife.
I thought you were David Yandel, and okay. Thank you. Okay, but ma'am, I want you right front and center for the testimony so that we can judge your credibility and so that you're right there in front of the screen and there, that's good. Could you raise your right hand? Do you solemnly swear that the testimony you're about to give today will be the truth, the whole truth, and nothing but the truth? So help you God.
Audio.
Ma'am, is that a yes?
No audio.
Audio. I've got you. Yeah, I've got them muted. This is not uncommon to not get the mutes off. That's my fault. I'm sorry, ma'am. Okay, we'll do this again. Do you solemnly swear that the testimony you're about to give today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, please state your name and spell it for the record, please.
Corian Yandel, Corianyandel.
Okay, Attorney Terry, your witness.
Thank you, Your Honor. Corian, what's your position relative to Harbor Park CrossFit?
I am a co-owner with my husband.
And how long have you been an owner?
5 years.
Okay. And the property that's at issue here, or your business property, that's at 3801 Blue River in the city of Racine, is that right?
Yes.
Okay. How long has that actual location been up and running?
We've had that location since June of 2018.
Okay. And your husband's affidavit covered on a lot of the factors, so we're going to be very narrow in my examination of you. And I just want you to explain to the court, not so much the immediate impact and the past impact of this order, but the future impact. Does that sound okay?
Yes.
Okay. So what's your position relative to Harbor Park when it comes to recruiting and retaining new members?
I am in charge of client success and incoming new members while they are going through the process of getting started, and then retaining them once they are with us.
And just educate myself and the judge a little bit. First step, how do you go out and recruit new members?
The ways that we get new members are often through referrals of our current members, through advertisement, mainly in Facebook.
Okay. What, maybe a stupid question, probably not my last one, but what's the importance of recruiting new members?
Most gyms have a typical turnover rate, or what we call a retention rate, that is about 90%. We like to keep ours much higher than that, maintaining members, but we do know that members are going to leave for various reasons. And with that, we need to have a constant influx of new members in order to replace the members who are leaving.
And just generally speaking, the process that you've explained, how long, and again, maybe I'm asking it incorrectly, but how long is the process to actually maybe advertise, bring in, and then subsequently, ideally, retain a new member?
With us being a CrossFit gym and offering a higher end services, they aren't as easy as typical gyms to get someone new to walk in. With us, we like to use advertising to expose ourselves to new clients. And with that, it usually takes about a month to 2 months of advertising on Facebook to explain to them who we are, where we're located, what our community is, and what we do. After they get exposure to some of our ads online or hear from other members in our community through several weeks, they typically come in for a trial or a consult. From there, they like to try a few classes and check us out for about a month or a month and a half before they decide whether or not we're a good fit for them. So acquiring new leads takes anywhere from 3 to 4 months.
Okay. And the existing order that's in place, how is that, and it's a broad question, but how is that affecting your ability to, I guess, ensure that you are bringing in new members? And I'll have one other question after that. Well, more than that.
With the current orders in place, we were not able to advertise for the 3 months that we were closed. Facebook is very in depth and takes some time to get your ads seen. And when we have to turn them off, it can take 3 or 4 months to get them back in circulation. So the fact that we've already been closed for several months is going to make us slow down when we do turn them back on. And it's going to take a while for them to pop up for those who are in our area and local. We haven't turned them back on because we're not able to increase the number of people in our gym, and we don't want to flood our gym right now. So we haven't turned them on yet.
When you say increase, you can't, or you're at a point where you can increase the operating capabilities of your gym, that's based on the order that's in place. Is that correct?
Correct, because we can only have 10 people in the gym at a time with our spaced out classes, and the amount of people per class, we're only able to get maybe 80 people. And we already have more than that in members. So we're not even able to give enough services to our current members. So we don't want to add more and face the fear that people won't be getting value for what they're paying for.
Are you seeing a level of attrition higher than normal based upon the conditions you're currently in, that being not only COVID-19, but the issuance of the safer Racine order?
Yes.
Okay. Just explain to the judge, if you could, if this order were not in effect, but COVID-19 is obviously still with all of us, how could you guys increase your services, ideally increase your revenues, even with the practices you're utilizing given the COVID-19 environment?
So right now we have a very large facility and we have an extra room in the back. We have plenty of space for larger classes and still being able to abide by the social distancing. So we could increase our classes to accommodate more people at more times, and that would increase our monthly revenue. We also get a lot of revenue from in-person sales of items on the shelf and through new members trying those trials. Right now we can't advertise for new members and aren't really pushing trial members. So that's a big loss of revenue for us right now. But if we were able to increase cap sizes, we would feel more confident to be able to get new people in and be able to sell those services as well. And one of the other things that we do offer is personal training. And because of one-on-one services, this also hinders what our coaches are able to do because they have to work when there's not classes. So they can't do one-on-one training as well.
Based on what I've heard you say, you've certainly felt, and your husband's affidavit lays that out, a substantial financial impact immediately. You also anticipate there will be even dire.
Your Honor, I've tried to respect the difficulty of doing this, and I haven't objected to many things that I would otherwise find objectionable, but I would ask Attorney Terry to not lead the witness at a minimum.
Sustained.
Based on what you've testified to thus far, Corian, what's the financial impact going forward for your business?
The financial impact is that currently we're not making enough money for the expenses that we have, and I fear that we won't be able to sustain.
I don't have anything further.
Okay, thank you, Attorney Terry. Attorney Letney, you're a witness.
Thank you, Your Honor. Ms. Yandel, what's your understanding of the Racine order that you're talking about as it relates to your business?
Can you please clarify what you're asking?
I want to know what your understanding is of the Racine order that you have testified about as it affects your business.
I believe that the order affects my business because it's limiting the amount of people I'm allowed to have in the gym to 10 at a time.
Okay, why is it that you believe the number limited to your gym is 10 at a time?
Because as far as I've read, that's what it states when you read the order for gyms in the city of Racine.
Ma'am, I'm quoting from the Racine order. Before I do that, let me ask you, do you know what the maximum capacity is of your facility under the law?
Not off the top of my head, no.
All right, and let me ask you this, prior to January 1st of 2020, what was the average class size for each of your classes?
We capped our classes at 20 and our average class size was between 15 and 18.
Okay, so I'm quoting from the order For gyms, this is on page 14, if anybody cares to read along. The limitation on capacity up to 25% of indoor capacity or 10 individuals, whichever is greater. So did you hear what I said?
Yes, sir.
Do you still believe that you are limited to 10 people in your facility?
The
Attorney
original,
Letney, where are you reading that? Wait, ma'am. Attorney Letney, where are you reading that? Page 14, I'm reading along with you.
I have the
Table
forward
2?
Racine plan. Let me look at this.
That's table 2, page 14, the second box over under start forward Racine.
Yes, thank you. I apologize. You were right. That is what I'm looking at. It says
Okay.
it relates to indoor recreational facilities such as gyms. And it says up to 25% indoor capacity or 10 individuals, whichever is greater.
I'm
So
looking at a
Ms.
version that I
Yandel-
received from the, wait, Attorney Letney, I'm looking at a version that I pulled off the city website and it doesn't say that. Attorney Terry, is that a correct reading of the current order under gyms?
I'm trying to find it and I didn't. And frankly, I think the argument goes to one of the exact problems with this thing. Maybe it changes tomorrow. Maybe it's 30% tomorrow. Maybe it's 2%. I think the clients have testified. I mean, this business is in an absolute tailspin based upon this order. We can talk about the 25% and run some.
Well, yeah, let's clarify what we're looking at here, because May 21st, 2020, there was a forward Racine order. It had page 14 of the one that I've got says under gyms, open, follow public health requirements and WEDC reopening guidelines, limited to 10 people if social distancing of 6 feet can be maintained. Has that been updated?
Judge, I just printed what I have in front of me off the city's website today, just so I have it here.
Well, that's the evaluate forward Racine potential plan for June 30th. Under that box, it says open, follow public health requirements and WEDC reopening guidelines, limited to 25 people if social distancing of 6 feet can be maintained? Or are you reading something else?
That is not what, I'm sorry, Judge.
No, it's okay. I just want us to be all on the same page. And again, I don't have an affidavit, I don't believe, with forward Racine. I went to the city of Racine's website weeks ago and printed this off from a link from the city, I believe. And if it's not the correct order.
Judge, we attached the forward Racine order to Yes, Judge, it's attached to the affidavit that I sent you. Affidavit of Scott Letney in support of the brief. It's Exhibit C. Page 14 of Exhibit C.
All right, just give me a moment.
So I have Exhibit C, but I don't see that it's 14 pages.
Well, it goes to page 5 with the order on the front and the forward Racine. It says revised May 29th, 2020. Is that the one?
That is the one that yes, Judge.
All right. I was looking at the non-revised version. My apologies, Attorney Letney.
I'm sorry, Judge.
All right, let me page down there to the page. It does have a page 14.
I got it.
No, Attorney Letney's correct. It says it right there. Up to 25% indoor capacity or 10 individuals, whichever is greater. If social distancing of 6 feet can be maintained based on occupancy permit. Okay, with that clarified, Attorney Letney, could, instead of reading the question back because it's a ways back in the transcript, could you ask you the question again, please?
Sure. Ms. Yandell, do you understand, at least now, that your business is not limited to only having 10 people in the facility?
Based on my understanding from emails from Bower Sox, she told us 10. If that's now changed, I've been updated.
Okay. In order to operate your business, you were required to apply for conditional use permits. Do you know what I'm talking about?
Yes, sir.
Okay. And were you involved in the application for conditional use permits?
I don't recall at that time.
Okay, if I tell you that the conditional use permit application that was filed on behalf of your business said class sizes will be capped at 10 people per class, is that something that you're familiar with?
That may have been for our original building in Racine that was up the road. That was much smaller.
Okay. When did your business start to decline since the first of this year?
As in, when did we begin to lose members?
When did you begin to lose revenue or lose members, whatever happened?
We lost revenue the day that we closed our doors,
Which was what day?
March 18th.
To your understanding, when did the city's order take effect?
March 18th.
Now, let me ask the question again. To your understanding, when did the city of Racine's order take effect?
The city of Racine, I believe, did it after the state was turned around, so May 26th, possibly.
Okay, if I told you that the city of Racine issued an order on May 13th, would that sound familiar?
Possibly.
Okay, so what happened in March of 2020 that was the fault of any order of the city of Racine?
That you asked if that was the beginning of our decline. That wasn't our major decline, but it was the beginning.
Okay, when was the major decline?
When the Stay Safer at Home or the city of Racine's order was extended.
So your husband filed an affidavit in this case? Did you assist in the preparation of this affidavit?
Yes.
The affidavit in paragraph 15 says that the business had gross membership monthly receipts for 2020 in February of $41,909.83. Do you see what I'm talking about?
Yes.
And do you see that it says monthly gross receipts for March were $20,175,000?
Yes.
Okay. So that, I'm a lawyer, not a mathematician, but that seems like your business cut in half between February to March of 2020. Is that right?
That's correct. We have a large amount of people that prepay for their services at the beginning of the year with bonuses and tax refunds.
Okay, so those are annual memberships you're talking about?
Some are, and some are monthly. We spread them out.
All right, so this says gross membership monthly receipts. So is that for monthly payments?
If you divided them up in the month,
Okay. And then April, $19,976. You see that? That's top of the next page.
yes,
All right, so that's just slightly down from March, right?
yes,
And then May, $18,014.
yes,
Again, continuing a downward trend. And June, $15,904, just a slight downward trend.
yes.
Okay. And then looking at the next paragraph, gross retail receipts. I'm just looking from April to May. It looks like the gross retail receipts went up 300% between April and May. Is that right?
We had members who were offering to provide financial assistance for those who were affected of COVID-19. So they purchased membership monthly payments for them, but we still have to spread them out over the next couple months. So we did get an influx of people trying to help.
The COVID-19 crisis has affected your business because of the pandemic. Is that true?
Yes.
How do you know why someone doesn't join your gym?
We asked them.
Why? How do you know if someone doesn't even contact you why they don't join your gym?
I do not.
So people could be not joining because of the pandemic, and it has nothing to do with any health order. Isn't that true?
I wouldn't know.
And your husband is David Yandel, yes?
Again, yes.
Okay. And if I told you that Dottie K. Bowersock sent an email to David Yandel on May 28th telling you that the indoor capacity, 25% of indoor capacity, or 10 individuals, whichever greater, is the amount that's allowed in your gym. You tell me you don't know anything about that?
No, sir.
All right, and again, you have no idea what the indoor capacity of your gym is.
No one's ever told us, sir.
I guess that's all I have, Judge.
Thank you, Attorney Letney. Do you have any redirect, Attorney Terry?
Just briefly, Your Honor. Corian, do you have current members that are demanding or wanting more services from your business?
Yes.
You kind of say it emphatically. Explain that.
We have a lot of members that really enjoy our community. They do a lot of things together, such as Pilates and extra mobility, yoga, strength training, personal training, barbecues, and we aren't able to let them do those services because we can't let anything overlap.
Okay. Last question. Have you, or to your knowledge, your husband attempted to contact anyone with the city of Racine, either the health department or city hall, in regards to this order or these orders?
Yes.
What have those attempts been?
In the beginning, my husband had attempted to email and contact the health department in Racine here to see if we could work together to have them come and see our gym and give us some guidelines and directive and show them what we were doing to help prevent the spread of COVID-19. And we were told that there wasn't any time for that.
Okay. Any attempted or actual contacts with City Hall other than the health department?
We also reached out to the mayor.
Any response?
That was the same response, was that there wasn't time for that.
Okay. I don't have anything further, Your Honor.
Okay, Attorney Letney, any recross?
No, Your Honor.
Okay, thank you for your testimony, ma'am. You can step down from the proverbial Zoom witness stand and
Thank
go
you.
back to sharing the video. Okay, back to you, Attorney Nudo, I think, or is Attorney Terry's taking it from here?
Your Honor, I believe we're satisfied with our presentation to this point.
Okay, two more points that I'd like you to cover, though. You've got two of the Werner factors under 80 Wiz Second 513 talked about today. Your brief mentioned them all, but I'd just like you to briefly cover why your client doesn't have an adequate remedy at law and why the injunction is necessary to preserve the status quo.
Sure, Your Honor. My client does not have an adequate remedy at law because they are under imminent threat of business closure. Unfortunately, this court nor any other court could adequately remedy the closure of a business. Once a business is closed, it's closed. It's irreparable harm. I cited in the supplemental brief to, I believe it was an Indiana case where it discusses in large part where a closure of a business is irreparable harm because a court can't undo that. So that's why there is no adequate remedy at law here, because once the business is closed, it's closed forever and it's closed for good, and that can't, the bell can't be unrung. So to that end, with the status quo, to maintain the status quo, to keep the business open, the status quo is to keep the business open. To maintain that status quo, a temporary restraining order is required from enjoining the city from enforcing this order. And until the discussion or the matter can be adjudicated on the merits, that is the status quo, is keeping the business open.
Okay, thank you for those two quick last points. Okay, Attorney Letney, it's your case.
Thank you, Judge. I'd just like to make some opening remarks before I address the issues that you discussed with Attorney Nudo. This is ultimately a case about the police power of a municipal government to deal with what goes on within its borders. As we all know, police powers are omnipresent. They're required to have a safe and orderly society, whether it's things like how to construct a road or how banks deal with their depositors, or what a speed limit is on a particular highway. Those are all exercises of police power. And those are common, and we're all used to those kinds of things. Zoning exists within the authority of municipal government to deal with how businesses operate within a municipality. There are residential zoning districts, there are industrial, there are business, there are institutional zoning districts, and they all regulate the way businesses operate. That is common. We all accept that. We all understand that. And there are good reasons for that. We don't want a blast furnace in a residential neighborhood. We don't want adult-oriented businesses next to daycares. Some businesses and activity exist because they're permitted, so they exist as of right or privilege for owning property there. Some are conditional uses, and you have to ask the city or the village, wherever you are, for the authority to operate. And you are granted a conditional use permit, generally speaking, with conditions, a conditional use permit. The way businesses may be operated is always regulated, and in very many cases because of health issues. Landlords aren't allowed to rent residential properties that have lead paint. They must provide adequate heat source. Businesses can't operate without adequate parking for patrons. A certain number of parking spaces may be required. Businesses can't exceed certain occupancy levels. That is common. That exists all the time. And the way businesses operate, Judge, there's a lot of lawyers on this call. All of us in law school learned about the Triangle Shirtwaist Factory fire.
Learned about what? Learned about what?
Yes.
Learned about.
Yeah, we couldn't hear the something factory fire.
Yeah, all of us in law school learned about the Triangle Shirtwaist Factory fire in 1911, where businesses were sealing doors and there was a fire and employees and other people there couldn't get out. That changed regulations based upon local police power. Nowadays, doors at businesses are required to open out rather than in. So if there's a fire, people can get out and aren't trapped by the door. It's simple things like that. There are many, many health-related examples to the way businesses are operating. The City of Racine Health Department employs sanitarians whose job is to inspect businesses like restaurants, for example, to make sure that the kitchens are clean, to make sure that food is held at 40 degrees or less, to make sure there are hand washing sinks in kitchens. I mean, we wouldn't want to think that a server is bringing our food out after going to the bathroom and not washing their hands. That is a regulation that's imposed by law. Local government is responsible for dealing with these things. And we saw, frankly, after the Palm decision was issued, and while the Order 12 and Order 28 were in place, a hue and cry that said this should not be a matter of statewide concern. Local officials are the ones that should be doing that. A member of the state legislature says this is something for a local government to do immediately following the Palm decision. And Judge, I think there's an irony here that we have to address the fact that we are holding this hearing virtually in several different locations because there are orders in place that say courts in Racine County can't have in-person hearings. And I think it's interesting, Judge, as a useful aside, we are here in the 2nd Judicial District of the state of Wisconsin, 3 counties, Racine, Kenosha, and Walworth. There are 20 or so municipal courts in the 2nd Judicial District, and the chief judge of the district has said whether municipal courts can open depends on what's going on in each individual county.
Right, and that's based upon the Supreme Court controlling the courts. The Supreme Court of Wisconsin has told each and every court, including this trial court, how they can operate. And they've decided they have that power, and I'm not going to comment one way or the other of whether I think they do, but they're exercising their power to run these courts. I'll have you know that the county of Racine, people can come and go in this building without masks. They encourage them to socially distance. They're being encouraged to wear masks, but ultimately they're not being ordered to in this building. This courtroom, however, you're right. We are in Zoom, and we are honoring the Supreme Court's orders, as well as our Chief Judge, Jason Russell, but it's an order, and it's a different order than what we're dealing with here. I think you're suggesting that Ms. Bowersox has unlimited police power under 252.03. Is that where this is going?
Absolutely.
And if it is, I want to know what the limits of her police power are and where it's stated in that statute that she has any limitation at all on what her police powers are, to the extent you're claiming that they are under 252.03.
Well, Judge, I'm not suggesting they're unlimited, and it would be unfair to anyone to say that I suggest they're unlimited.
Oh, wait, okay, well then show me in the statute where it's limited. Where are the limitations on her power? Because the Supreme Court couldn't find any for the Secretary of Health, and so they struck her powers and said, you don't have those unlimited powers. You're an unelected bureaucrat. This statute doesn't say you have those powers, and to read it that way, Secretary Palm, is not what you have. You have rulemaking authority, and if you want to make a broad rule for the state, you can do it. You've just got to go through 227, I believe, is the statute. For Administrator Bowersox, she can't make rules, and she doesn't appear to have any guideposts, limitations to her power, nor the duration. Governor's got 60 days for an emergency. After that, he's got to behave and not behave. I mean, he's got to get together with the legislature, and they all have to put their heads together and come up with a response to the pandemic. Now, they haven't done that, but that's the statute for governor's 60 days emergency. And they, at least the legislature, thought that 60 days for the governor to exercise vast emergency powers was enough. There's no 60-day limit for Ms. Bowersox. I don't see any limit. So before we go further, let's figure out where in the statute her limitations are, and if not, what you think that they might be.
Well, Judge, what statute are you referencing? You talked about several statutes in an administrative code with Mr. Nudo. I want to know what statute you mean so I can address it properly.
Well, let's start with the statutes that she's been relying on to pass her orders, 252.03 sub 1 and 252.03 sub 2. And I quote, she keeps quoting these, so let's talk about them. Under sub 1, the local health officer shall promptly take all measures necessary to prevent, suppress, and control communicable diseases. And then sub 2 also has a provision similarly worded. It says local health officers may do what is reasonable and necessary for the prevention and suppression of disease. Now, COVID-19 is a communicable disease. It's also a disease. So is diabetes. So is heart disease. And the way that I believe Administrator Bowersox may be reading her powers is that she has the power to control all diseases, or I'm sorry, prevent and suppress them. And if there aren't any guardrails on her power, what's to stop her from banning restaurants from distributing salt because of high blood pressure and maybe heart disease, or banning sugary drinks from being sold in the city because that's going to cause diabetes? And of course, she could also prevent and suppress disease if she bans alcohol, so no one gets liver cancer or liver disease. That's how I read her ability. If it's broad, there's one part in sub 1 that talks about communicable diseases, but sub 2 is all diseases. And as I'm sure most people know, I looked it up, everything is a disease almost. So if that's the case, then Administrator Bowersox can control every aspect of people's lives in Racine. And I'm wondering where it says that in here.
May I, Judge?
Or maybe I'm reading it wrong, but I need you to clarify for me where these guardrails are that would make her power as a local official that broad, actually broader than Secretary Palm's. I mean, I'm throwing a lot at you, but this is right in the red target of this case, because as I noted from the Palm decision and reading it many, many times before today, when pushed on the issue at oral argument at the Supreme Court, Counsel for Secretary Palm said, "Wait, they're not unlimited powers. Her powers are only," and they look to sub 6. The department may authorize and implement all emergency measures necessary to control communicable diseases. They said, "Whoa, her power isn't unlimited, Supreme Court. Her power is in emergencies. That's the guardrail for her power." Supreme Court didn't buy it and said she didn't have any of the power that they claimed that she did. But that was her only guardrail she could think of. And so I need to know what Administrator Bowersox's guardrails are to the extent of her power under 252.03 sub 1 and under sub 2.
Thank you, Your Honor. I just wanted to be sure because you had talked about 252.06 and 252.07 with Mr. Nudo, which are in opposite to this because they deal with something entirely different. Judge, first of all, I have to say I utterly disagree about what the Palm decision said. The Palm decision said, one, that state agencies are required to follow this rulemaking procedure, and Secretary Palm did not. All right? There is no parallel in local government that requires this particular rulemaking procedure. So that part of the Palm decision is utterly irrelevant here.
Well, wait. So wait. I want to understand what you're saying. So you're saying that because Bowersox can't make rules, that she's got the power to issue general orders of general application because she can't make rules? Is that what you're saying?
That's not what I'm saying, Judge. The court said that Secretary Palm did not follow the rules. The court didn't say anything about local public health officials, didn't say anything about 252.03. That case has nothing to do with this situation. They are completely irrelevant to each other. The court certainly did not say statute 252.2 is unconstitutional. It certainly did not say that. The court said rulemaking procedures and it said, closing of businesses and transportation and telling people to stay at home is beyond the Secretary's authority under 25202. That's what the court said. And you quoted exactly what I would have said, Judge, that the local health officer, upon appearance of any communicable disease in his or her territory, shall promptly take all measures necessary to prevent, suppress, and control communicable diseases. And local health officers may do what is reasonable and necessary for the prevention and suppression of disease. So the standards there, Judge, are all measures necessary, and then what is reasonable and necessary. In this case, Judge, what Administrator Bowersox did was extremely measured, very specific, and limited in duration, and appropriate under the circumstances. On May 13th, when the Supreme Court issued its decision at close of business on that day, all of a sudden, after being essentially shut down for 2 months, the state of Wisconsin was open again. The city of Racine County and the city of Racine have been hotspots for COVID. This was of significant concern to her based upon her education experience and years as a public health officer. She realized something was needed in that moment, so there could be some sort of transition between where the state had been for all that time and what was sure to come, which was businesses and the city opening. So she put into effect an order on May 13th that continued the similar provisions that had existed under Emergency Order 28. People were used to those. They understood what those were, and it was of a very specific duration, Judge. It wasn't unlimited. It didn't go beyond that. It went until May 26th at 8 o'clock in the morning. And at May 26th at 8 o'clock in the morning, a new order was put into place. And if you read the entirety of that order, Judge, essentially what it is a series of suggestions and guidelines for the ways people should behave. And there were some very specifics, including limiting of people that are inside facilities. And by the way, Judge, I referred to it, but the city's building inspector tells me capacity is 99 for the facility that the plaintiffs have. So they could have at 25% of capacity, essentially 25 people there at any one time. And that forward Racine order specifically says it's going to be reevaluated on June 30th. So when it went into effect on May 26th, largely with guidelines, some kind of indoor capacity issues, and an intended date to reevaluate, this was again a very limited, very measured order that was implemented. And it makes sense, especially in a business like a gym, to have a limitation on the number of people that are there. We all know that COVID-19 is transmitted through people breathing in the air. There is a high degree of respiratory transmission when people exercise.
Okay, but I'm not, Attorney Letney, I'm not even there yet. The reasonableness, whether it's good, bad, this, that, or the other thing, I'm looking at whether she's got the power to do it. Would you agree, Attorney Letney, that her orders are, to this date, all of them, have been general orders of general application?
Yes.
Okay. And where is the guidepost for her power? Where does it end? What can't she do under 252.03 sub 1, sub 2 to prevent and suppress disease?
She can't do something that is unreasonable and oppressive.
And who decides that?
Well, Judge, honestly, it's the public health official that decides that.
So she gets to decide she gets to decide for the city of Racine, her solely in her mind, whatever she thinks is reasonable to do to prevent and suppress disease, and she's got the statutory power given to her by the legislature to do that. Isn't that a despot?
I don't agree, Judge. This is part of the exercise of authority of a municipal government. Ms.
Okay, so
Bowersox,
what can't she do? You told me she can do whatever she wants. It's reasonable. Is that reasonable, necessary? Are those the only guideposts to her power?
Judge, if I look at the Bowden versus Milwaukee case, which I cited.
Wait, is that that 19? Wait. Is that 1909 case?
No, it's 1959, Judge.
Okay, is it before the present administrative state on the communicable diseases and DHS and all that stuff we're looking at?
I believe it is, Judge.
Okay, so why would that still be? Why would that be persuasive to me on police powers if it's going to be? I'll let you get it out, make a record. But if that's before 252 was enacted, or if it was before the Department of Health Service even existed, it's going to have tenuous. It's going to have tenuous precedence for me.
Well, let me just say, Judge, in the Bowden case, which was 8 Wisconsin 2nd 318, the Supreme Court said that anything that is not unreasonable or oppressive is within the authority of a local health official. And let me just say, Judge, when you and Mr. Nuno were talking, you talked about all of DHS 14506, except the one that's actually relevant in this case. And
I know you're referring. Okay, you're referring to sub 5 of that provision.
Sub 6, Judge.
Sub 6, yes. Okay, hazards to health. Okay, let's hear it.
All right, so it says that officials empowered under 252.03.1 and 2, the relevant statute that we've talked about. And Judge, I just want to say as an aside before I get to that, because I meant to say it a moment ago when you asked me a question. Administrator Bowersox is the local public health officer for the city of Racine. She was appointed by the Board of Health and unanimously confirmed by the Common Council of the city of Racine. So there may be people say she's not an elected official, but it's not only elected officials that are officials of a municipal government. She was confirmed unanimously. I mean, it would be fair to say the entire city of Racine approved her appointment, and she has the authority under the law to make these decisions. So if we look at 145.06 sub 6, local health officials under 252.03.1 and 2 may direct persons who own or supervise real or physical property or animals in their environs which present a threat of transmission of any communicable disease under sub 1, which of course lists all the communicable diseases, to do what is reasonable and necessary to abate the threat of transmission. Again, the reasonable and necessary language is there. We are talking about Mr. Yandel and Mrs. Yandel who own or supervise real property and physical property because they own all the equipment in the gym, and the local health official may direct those people where there's a threat of transmission of any communicable disease. As I said, Judge, we know that COVID-19 is transmissible through the air. People breathe out, people breathe in, and that is a principal way of transmission of COVID-19. Anybody that's ever exercised knows you breathe heavily. You're next to somebody that's breathing out, you're next to somebody that's breathing in. That is a threat of transmission of a communicable disease as listed under the administrative code. And the local health official can direct that person, this is really specific to this case, Judge, can direct that person to do what's reasonable and necessary to abate the threat of transmission. So
okay, I'll walk with you on that for a second, but you're leaving out the last part. It says persons failing or refusing to comply with the directive shall come under the provisions of sub 5 in this subsection. And what that means is if a directive isn't being followed, she's got to go to court and get a court order to get it enforced. She hasn't done that. So if this is directly on point, you're telling me that she's violated the DHS code because she doesn't have that order. Yet she's pretending that she does.
Judge, it says if somebody's not obeying the order. I don't know whether Mr. and Mrs. Yandel are not obeying the order. I hope they are. People obey the law because it's the law. If they're not obeying it, then she can decide whether or not to go and have it enforced specifically against them.
And,
But
what's the enforcement mechanism? I mean, you're coming right, I mean, you're saying what I'm thinking, and it is, what is the enforcement mechanism? First it was, I thought 252.25, then there's some mention in our orders about a forfeiture. What is this forfeiture? Where is it? How much is it? And how do people know what they might be forfeiting by violating her directive or her order?
Well, Judge, in Chapter 54 of the Racine ordinances, it says that the health officer, this relates to the authority of a health officer, who is charged with enforcing, operating under Chapter 252. It says that it's the duty of the health officer to enforce this chapter, and any person charged with violation of the offenses may cause to be forfeited the amount that's listed under the statute, and or the ordinance. There's a catch-all section in the ordinance under section 115 that lists forfeitures. I can't tell you off the top of my head what it would be, but.
Okay, well, are we looking then at the amount that was actually a fine or imprisonment of $500, fine of $500 or imprisonment under 252.25? Is your argument that the forfeiture is at $500?
Obviously not, Judge, because 252.25, the criminal statute enforcement mechanism, said it was a $500 fine. A fine is a criminal penalty. It's not a civil penalty.
I understand that. I understand that.
You can't be in prison for failing to comply with the municipal ordinance. That doesn't exist. So the forfeiture is as is in the ordinances. And I think the specific ordinance, there's a catch-all that says maybe between $1,000 and $1,000. The police department was directed to set the bond amount, which is not necessarily the forfeiture amount. It's up to a municipal judge, as you know, to decide the exact amount of the forfeiture. But the bond amount was to be listed at $565, I believe, is what it was. And then the case would have to go to a municipal court for determination. I indicated, by the way, Judge, that there were no citations issued in the city of Racine for any violation of the May 13th order. I'm not aware of any, frankly, by the way, for anything that happened after May 26th. I do know there were some citations, some civil forfeiture citations issued during the period that the state's order was in place, but those have all been dismissed once Emergency Order 28 was ruled invalid. So those don't exist. I mean,
I don't see any of this reference in the orders, though. I've got the May 13th, 2020 order in front of me, and I'll read the last sentence of it. I know it's no longer in place, but I want to get an understanding of what's being ordered here and whether it's still in play. Last sentence of that says, violation of or failure to comply with this order is a Wisconsin statute section 252.25 as adopted by the City of Racine Municipal Code of Ordinances section 22-424, punishable by forfeiture. What does that mean?
Well, in order for a municipality in the state of Wisconsin to enforce state statutes, they have to adopt the state statute, the violation of the statute. The most common that we see is the traffic code, which municipalities can adopt. And under Chapter 66, a municipality can adopt all kinds of criminal violations, but they still can only be enforced as civil forfeiture violations. If they're issued to they're civil forfeiture violations.
Go on.
I was going to say, if they're issued,
that's okay. You finish, and then I've got to.
I was just going to say, if they're issued to a municipal court, they are civil forfeiture violations. That's all they are. And the police obviously have the discretion to issue something as a criminal charge or a civil forfeiture violation. We don't deal with criminal charges in the City of Racine Court.
All right. So Racine Municipal Code of Ordinances section 22-424, as I read it, incorporates by reference most of the statutes, but it also incorporates 252.25. Is that correct?
It does, Judge.
Okay, and is a violation of Ms. Bowersox's order a violation of 252.25?
Well, it's a violation of a health officer. Let me pull that statute up, Judge, just so I'm clear.
Okay, because I don't see that she's got, I don't see that her orders under 252.25 have any enforcement at all under that statute. And I'll read it here while you're spooling up your computer to get it. That says any person who willfully violates or obstructs the execution of any state statute or rule, county, city, or village ordinance, or departmental order under this chapter and relating to the public health, for which no other penalty is prescribed, shall be imprisoned for not more than 30 days or fined not more than $500 or both. And I understand perfectly what happened in Palm with that being found problematic, but I don't, departmental orders are listed there. Ordinances are listed there. What's missing there, though, Attorney Letney, is local health official order. It's not mentioned at all, but they specifically mentioned departmental order. So I'm wondering why Administrator Bowersox is referencing that statutory provision, basically saying, if you don't do what I'm doing, you're violating 252.25 as incorporated by Racine Ordinance 22.424, and you're going to pay a forfeiture. If she doesn't have any power under 252.25 to enforce her orders, which it looks to me like she doesn't, how then is she able to punish anyone in Racine with a forfeiture?
Well, she doesn't issue citations to punish people with forfeitures. That's obviously a police department responsibility. But I would point to, Judge, and I understand that the order references 22-424, but also in Racine Ordinances 54-27, which is the communicable diseases article of Chapter 54, the provisions for the control and supervision of communicable diseases as established by Wisconsin Statutes Chapter 143, which is the predecessor to Chapter 252, are adopted, and the rules adopted by the State Department of Health and Social Services pursuant thereto are adopted by reference and made a part of this article as though set forth fully herein. Any future amendments, revisions, or modifications of these sections, the statutes, are incorporated herein, are intended to be part of this article. So there is enforcement ability there. Judge, the important thing
with 252.25 or in the absence of it?
All of Chapter 252 is incorporated into this section of the Racine Ordinances.
But she has no power to enforce her orders. A violation of her orders is not a violation of 252.25. I'm wondering, am I correct in that? And if so, then why is that statute even referenced in her May 13th, 2020 order?
Judge, I don't believe that you're correct in that. The entire chapter of 252 is incorporated into the Racine Ordinances, and the authority in the city of Racine to enforce that is granted to the public health administrator as the local health officer. And frankly, Judge, if all we're worried about is enforcing this through civil forfeiture, then we've completely failed. If the people are not willing to comply with a perfectly reasonable order of a local health official, then Judge, it doesn't matter. It doesn't matter. You're right. If we can't issue a civil forfeiture, then what's the point? I guess that's what you're saying.
Well, no. The point is that you've threatened every citizen of Racine with forfeitures, and the point may be that she might not have that power to do that. And if she did that in her order without the power to issue a forfeiture, that is a problem. That's a big problem. And we're going to get to the bottom of it today. Maybe you can tell me how I'm reading that wrong, but you're basically saying that she can incorporate 252.03 and her general powers to issue general orders of general applicability. But 225, the violation portion of the counterpart for the Secretary Palm's power, she doesn't have a violation of whatever her orders are, isn't a violation of law relating to health under 255.25. There's nothing there that says public health orders. So if she doesn't have that, how can she tell people to do something and then there be a penalty of forfeiture? That's really what I need to get an answer to.
Judge, I apologize. We lost you for a second. The computer went dark. I believe you were
Okay.
asking about the relation of 252.25 to the situation here. So again,
No, I was a little more specific than that. What I asked for is Ms. Bowersox put in her order that it was punishable, it was enforceable through 252.25 with the forfeiture. She put that in there. She chose those words and issued an order on it. And every citizen of Racine is facing, potentially believes they're facing a forfeiture violation if they don't listen to what she wants them to do under order. What I'm saying is, it doesn't say anything in 252.25 that a violation of a public health official's order is a violation of 252.25. And if that is indeed the case, why did Ms. Bowersox put that in her order? And how is her order enforceable on anyone in Racine?
Judge, all of Chapter 252 is incorporated into a city ordinance, which is, in addition to 22-424, also incorporated into 54-1. When a municipal government incorporates a statute into an ordinance, which the city of Racine has done, it has adopted the provisions of that statute. The city of Racine has empowered the local health officer to enforce the particular ordinance here. So this is an issue that falls squarely under 252.25. By violating the local health officer's order, a citizen, a resident, whomever would have violated Racine ordinance that is adopted. And that is specifically what the issue, what Chapter 2 or 252.25 says. If any person who willfully violates or obstructs the execution of a city ordinance under this chapter relating to the public health, that's exactly what this is.
And what does the city ordinance say about shutting the city down on a pandemic? Is it that specific?
Judge, to be honest, none of us alive have dealt with a pandemic, and certainly not one to the extent that there were some epidemics. They haven't been to this extent.
Why doesn't the order reference that? If that's really what she means and not what she wrote, which doesn't say that anywhere that she wrote. If that's really what she meant, how hard would it have been for her to put that in her order so that citizens of Racine can go and say, okay, it's ordinance. She's enforcing ordinance 54. It's not in here. I mean, I've looked repeatedly. All this says is that she's incorporating all the statutes through 22-424, and it's punishable by some type of amorphous forfeiture that she didn't care to tell the rest of the city what that forfeiture would be, where it's located, what ordinance she's referencing. And I'm quite frankly not sure how anyone in the city of Racine would be able to find that. I couldn't find it. No one's referenced it. I looked at 54. I didn't see anything in there that says that she has the power to issue general orders of general application to shut the whole city down, sick and non-sick, infected businesses or non-infected businesses. And the Supreme Court in Palm said that Secretary Palm didn't have that ability to do that without rulemaking. But that's what she's doing here. And that's what, at least I believe, concerns the plaintiffs in this case, and that they are under this order. They don't believe she has the power to do it. Their business is getting harmed, and now they're challenging her on it. So I'm still not convinced that there's anything in 54. It's certainly not in the briefing. It's not in the orders. It's never been referenced until today's oral argument. I can't imagine anyone in the city of Racine has any idea what this forfeiture is, unless they've been hauled into court and someone's told them it at the last minute. I don't know if that really meets the publication of laws requirement or ordinances. I mean, people, it's not a crime. It's not a fine, but it is a penalty of some sort, and it's taking money from people for not doing things that Administrator Bowersox wants them to do. And this court's very troubled with the lack of specificity in these orders of any of that, because that all, to the extent it's true, it's not in the order. And this is a labyrinth of things that your normal citizen doesn't understand. And maybe Administrator Bowersox didn't think it was reasonable and necessary to tell them this, but she did think it was reasonable and necessary to shut the city down and now reopen it under the way that she wants. And I get it. There's a pandemic. She could be making the best decision in the world. She could be saving Racine and making the best decision for everyone, or she could be making a bad decision or a neutral one. But if she doesn't have the power to make the decision, this court doesn't have the power to let her do it. Whether I like what the ramifications of that are or not, or how it affects the city's ability to control the pandemic. Because at the end of the day, she has powers derived by the law, or she doesn't. And if she doesn't, then the city of Racine would fall back to what Mount Pleasant is doing, and Caledonia, and Sturtevant, and all the other communities that aren't currently under a reopen plan. And I do note that just geographically, it's neither here nor there in my decision and what I'm going to do today, but Mount Pleasant winds all the way through the city of Racine in an odd way. And, at some points of this city, there's a shutdown on one side of a block. There's a couple blocks maybe that don't have a shutdown. Then there's another shutdown. And then it winds its way through the city. And you say she's doing what's reasonable. And I'm not here to judge that. I don't know. I'm a judge. I'm not a health official. I'm assuming that she's doing exactly what she thinks is going to protect Racine. And that's commendable. It's commendable that the mayor is doing what he thinks he should be doing, as well as you, Attorney Letney. Those are all their jobs, Common Council as well. They're doing an excellent job in a difficult time. But this court doesn't have the luxury of making policy. I don't have the luxury of being able in this instance to turn my eye on what the law says, what the law allows someone like Administrator Bowersox to do. My only job is to analyze the law, tell you what I think, and then if you don't like it, you get a kick at it at the appellate court or maybe the Supreme Court. And you've got lots of due process relief valves. It's certainly a lot more of the due process relief valves that you guys are going to get than anyone in the city of Racine has gotten in the last couple months. Mr. Yandel is the first one in the city to step up and sue and say, you know what, I don't agree with this. I don't like it. It's harming my business. And I don't think Ms. Bowersox has the power to do it. So that's how we ended up here. And I have taken to heart, Attorney Letney, your passionate arguments as to why this is good for Racine, that these aren't very onerous restrictions. She's doing a great thing for Racine. And I'm taking all that as true for my decision today. I have no reason to doubt that. But for today's purposes, I'm just looking at her power to issue general orders or general application under 252.03, and whether, if she has unlimited power, whether that's something the legislature anticipated when it wrote that statute, or whether it's something it could never have anticipated and that she shouldn't be able to wield, and that perhaps she should be wielding the power that the Secretary of State, Secretary of Health Services, Secretary Palm, the Secretary for the State Health, she can only issue. She can no longer, after Palm, issue general orders or general application unless she goes through rulemaking. Currently,
Judge?
Yes.
I'm sorry. I wanted to respond to something you said here.
No, I'm not going to rule yet. I'll let you put on the rest of your case.
Okay. Judge, honestly, you just made my point. You said that she has done what she believes is reasonable. You don't know whether it's reasonable because you are not a local health officer.
I agree with that.
She is a local health officer. And honestly, Judge, the branches need to pay deference to the authority of the other branches. I've cited a number of cases where courts have said judges shouldn't get involved in these kinds of decisions. But the standard is not that she can do anything she wants. She has to do what she deems to be reasonable and necessary. That is not an unlimited power. She has not exercised She has not exercised unlimited power. You can't suggest she has. Nobody has. She has done what she believed to be reasonable and necessary under the circumstances. And you just said that you understand that she did what she believes is to be reasonable.
Right,
That-
but no, stop. But what you don't seem to have your arms around yet is that under that statute, I do get to determine ultimately whether I think it's reasonable and necessary if it comes to my court. I get to determine ultimately, and then the appellate court and Supreme Court, of course, if I don't think something, if that was the issue before me, while I don't have any reason to doubt it today on this record, I would have the power to say, that's not reasonable and necessary, Administrative Bowersox, and I'm not going to let you do it under the statute. Because if I don't have that power, Attorney Letney, then she really does have unlimited power. Because anything she feels in her head as an individual is reasonable and necessary, she gets to do. That's the definition of unlimited power. And these courts have previously said that having a judicial relief valve for that exercise of power isn't a guard post on it. So I say I could ultimately say she isn't being reasonable under the statutes. Courts have that power, but your argument isn't right. The courts do have the power to tell Ms. Bowersox what's reasonable and necessary, but that's not an issue today, which is why I said I'm taking for today's decision that what she did is reasonable and necessary. Under this record, I have no reason to doubt it, and I don't have a record on it. There haven't been scientists brought in. I don't have curves of COVID infection rates and things in front of me to understand transmission and all of that. This isn't that case. It's not going to become that case. But no, I take issue with what you said, Attorney Letney, that I don't have the power to correct what's reasonable and necessary in the mind of Ms. Bowersox. So I'll let you continue presenting your case. I'm sure you got different things to say about the TRO. I read your brief, obviously, but I'll let you continue. We've gone into the weeds on 252. I think we've severely flogged and beaten a dead horse now, and I know where you all stand on that. So let's keep moving to the rest of your points.
Well, except that, Judge, I would ask you not to make a ruling on what she could have done, but what she did, which you have said you agree is reasonable and necessary. I do agree that the issue is moot. Because the order that was complained about was the May 13th Racine order, which expired by its own terms on May 26th at 8 o'clock in the morning. I realize that we have discussed the forward Racine order, which occurred starting May 26th at 8 o'clock in the morning. And I did that out of respect for you, Your Honor, because you asked us to do that. But I would object to any ruling based upon that because that really isn't before you. Let's be honest about that. Plaintiff's argument that this order is negatively affecting his business it's really difficult to say. It's really easy for them to stand up there and say, well, this is going to cause us problems. But she said it takes 3 or 4 months to develop the business. And when they were shut down, starting in March, they had problems. Well, respectfully, Judge, that's not on the city of Racine. That's on the state of Wisconsin. And if they have a problem with what the state of Wisconsin did, then maybe they need to sue the state of Wisconsin about that. But the question is, what about these 13 days between May 13th and May 26th? They haven't said those 13 days made a big difference. And frankly, Judge, and they can't. And they can't say, they truly cannot say whether it is the orders that were in effect or the fact of this COVID-19 pandemic that has affected the way people have behaved. We know there are a lot of people that still today are afraid to go out. And Judge, I'll let you've been doing this a long time and you've handled a lot of business issues in your career. You know, if we look at their monthly receipts and the retail sales and the expenses, there's not a significant change that has occurred. Certainly not this attributed to May 13th, the order that was issued on May 13th. So they haven't demonstrated, Judge, to any appropriate standard that, in fact, the May 13th order has affected or will continue to affect their business. And we know it won't continue to affect their business because it's done. It ended on May 26th. I would like to address the case that Mr. Nudo cited in his supplementary brief, a 1994 case from Indiana that is utterly irrelevant to the issues that we are deciding here today, this family and social services case. First of all, it was based on Indiana law, and at least as of that moment, temporary injunction standard for under Indiana law wasn't that irreparable harm was a single standard like it exists, or a single prong like it exists in Wisconsin. It wasn't a single element separate and distinct from inquiry into legal remedies. It doesn't apply, and the facts are completely inapposite to what we're doing here today. That case was about government funding, Medicare reimbursement, going to a nursing home, and if the funding wasn't received, then the facility would close and 81 severely mentally handicapped residents would be displaced. That is an utterly separate issue that is completely unrelated. Judge, the point is that as to this argument, whether or not there is a legal remedy as opposed to an equitable remedy available to them. And if the Yandels can prove that between March 13th and March...
He's garbled.
Yeah, we're getting garbled. Hold on, Attorney Letney. We're getting garbled again. Just give it a pause. Okay, please rewind that last two sentences.
So what I said is the issue is as to legal versus equitable remedy available. If the Yandels can prove that the May 13th order, which was in place for 13 days, actually caused their business harm, that is demonstrable through, I don't know, some accounting records, receipts, whatever it is, and that the city did something wrong that caused them that harm, then they certainly do have a legal remedy. And they can deal with it that way if they want to. There isn't any law that says loss of business, repayment for loss of business is not an available legal remedy to someone. So that is simply a matter of fact. And again, Judge, I said, but I'm going to say again, there is no way they can know whether somebody didn't decide to join their gym because that person is afraid of COVID-19. They are afraid of exercising in a close proximity to other people who are exercising. And frankly, you know, I know all about the plaintiff's gym. I think it's a great business. It's great for the city of Racine, but they are in the business of helping people be and stay healthy. And this is unquestionably a health crisis, and they need to understand that that is an issue here, and that's something in effect. Judge, I need to address the last prong, likelihood of success on the merits. I realize, Judge, that you and I have disagreed in our dialogue about this, and I certainly disagree with the way that attorneys Nuno and Terry have characterized the Palm decision. The Palm decision didn't say anything about whether or not these kinds of orders are appropriate. They didn't say whether they're a good idea. I mean, there's a lot of dicta there. There's no question. There's some additional opinions in addition to the decision of the court, but the court made its decision principally and clearly on the fact that there is a specific statutory procedure under Chapter 227 for state agencies to issue rules. And they said that Secretary Palm didn't follow that. Now, that dealt with the state's power. It didn't deal with local powers. It's a completely different thing with different levels of responsibility. And I would at least, fail the court if I didn't mention the fact that there is an issue of home rule, constitutional issue of home rule that's available to municipal governments in Wisconsin. Municipal governments do have the authority to decide in cases that are not of statewide significance, situations that are not necessarily statewide significance, to determine what is best for the municipality. And that's what occurred here. There is a difference between Section 25202, which unquestionably the court did not deem to be unconstitutional, and 25203. There is a flaw in the logic that says a decision as to one has something to do with the other. The Attorney General of the state of Wisconsin said clearly that it didn't have anything to do with the other. And I will say, Judge, that there is, I didn't realize, frankly, that that we'd see this today, so I didn't put it in my brief, and I apologize, but I want to call the court's attention to a case out of the United States District Court for the District of Oregon, which is relevant here, Judge. It is open. Judge, I apologize. I have to keep moving my mouse, otherwise the computer goes out. It is
That's okay.
open our, O-U-R, open our Oregon versus Brown. It is, it's civil number 6:20-CV.
Wait, what was that?
773.
Civil 6, I couldn't hear. Civil 6, colon?
20-CV-773. I have a Lexus site that I can give you, Judge. It's
I don't have
2020.
Lexus. The court system only has Westlaw.
All right, Judge, I'm sorry, but this, as far as we can tell, there's two courts that talked about the Palm decision since the Palm decision, and this is one of them. And I just want to say that this court says plaintiffs pointed to the Palm decision, and that court says that case concerned only whether the Secretary Designee of Wisconsin's Department of Health Services failed to abide by the Wisconsin statutes authorizing emergency rules. I mean, even this federal court in Oregon recognizes that it doesn't have anything to do with the authority of the local health official. Judge, the whole, whether or not, I don't know, Judge. They don't meet the standards for a temporary injunction. It doesn't make any sense. And frankly, even if they did, maybe you can say it doesn't apply as to this gym, but they certainly haven't made any kind of ruling or argument as to citywide application. But they don't meet the standards. First of all, it's a moot, Judge. They haven't shown there's no legal adequate remedy at law. And Judge, honestly, I don't believe there's any way they can show that there's a likelihood of success on the merits. There isn't any precedential law out there that says a local health official can't do this. And I realize, Judge, you're a judge and you will help us decide what the law is today. You would be making this decision on your own, which you have the authority to do. You can't point to anything else that says that in the case of a pandemic, a local health official doesn't have the authority to do, to take these reasonable, measured, limited steps to carry out her duty, her responsibility to the health of the residents and businesses and other people that are in the city of Racine. You can't point to anything that says she can't do that. Certainly, plaintiffs can't do that. Judge, you shouldn't grant this injunction. It just doesn't seem to be appropriate under the circumstances.
Okay. Thank you, Attorney Letney. I've already heard the plaintiff's case. We're going to take a 10-minute break so my court reporter's fingers can unstiffen, and then we'll come back on the record and I'll make a ruling. So we'll go back on the record at, see, it's about 3:19 here. We'll go back on at 3:30, and I'm going to mute, but stay on Zoom. If you're on YouTube, stay on YouTube in case you might lose the link. This is going to keep running for 10 minutes of dead space on YouTube. I don't want to start a second YouTube channel, so I'm going to black out my screen, mute it. Everyone else can do the same. There's a button to block your video and block your microphone, but I don't know how fail-safe it is, so I would certainly suggest not saying anything you don't want the world to hear on YouTube. So we'll be back at 3:30. And thank you for the good argument from both sides. It was a really good argument from both sides, highly detailed. You guys know the ins and outs of these statutes and the things you cited. Court's very impressed by the argument. So thank you for that today, and we'll come back and I'll give you my ruling. before we go back on the record, my court reporter isn't back yet, but as soon as she is, we'll start going. I'm going to do a check with everyone's audio again before she does it to get, oh, there she is. Attorney Nudo, can you hear me?
I can, Your Honor.
Attorney Terry, can you hear me?
Can, Your Honor.
Mr. Yandel, can you hear me?
We can, Your Honor.
Okay, and Attorney Lutney, can you hear me?
Yes, Your Honor.
All right, great. Okay, well, as I said, I'm prepared to rule from the bench today. I'm not ruling on the fly. Prior to today's hearing, I've spent long hours and many days analyzing the statutes at issue, the Wisconsin Administrative Code, and the Wisconsin Legislature v. Palm case, 391 Wis. 2nd, 497. I've also looked at the rationale expressed by Attorney General Josh Call in his May 15th, 2020 opinion that was referenced by Attorney Lutney. I've also looked at Racine ordinances as part of my review of this case, as well as the orders that were issued by Ms. Bowersox, and also the current forward Racine order. And I've read all the briefs, obviously, and weighed the arguments. Case is not about whether Administrator Bowersox's orders were good or bad or necessary to control COVID-19. I've already stated that at least once in this hearing, if not twice. Now it's the third time. I want to be very clear. I'm not taking a position on whether she's doing is good, bad, or otherwise. This case is ultimately about one thing only. It's about whether she has the power to issue these orders under WSStat 252.03. For today's purposes on the issue of whether this court should temporarily enjoin Administrator Bowersox from enforcing her current forward Racine order or issuing any new general orders of general application, this court looks to four factors under Wisconsin Statute 813.02 sub 1 sub A. 1, does the plaintiff have a reasonable probability of ultimate success on the merits? 2, does the plaintiff lack an adequate remedy at law? 3, is there a threat of irreparable harm to the plaintiff? And 4, is the injunction necessary to preserve the status quo? These factors can be found under the case Warner versus A.L. Grutamont and Sons, Inc., 80 Wis. 2nd, 513, with a pinpoint site of 519 to 520 pages. On the issue of whether the plaintiff has a reasonable probability of ultimate success in the merits, this court looks to the Palm decision, as well as WSStats Chapter 252 and Wiz Admin Code DHS Section 145. In the Palm case, the Wisconsin Supreme Court held that the Secretary of Health does not have the power under Wisconsin Statute 252.02 to issue general orders of general application, such as her safer at home order. The court held that Secretary Palm could only do so through administrative rulemaking. Local health officials, unlike the Secretary of Health, do not have rulemaking powers. The City of Racine, Administrator Bowersox, and the Attorney General interpret this to mean that because they don't have rulemaking powers, they have the broad sweeping powers over their local communities that Secretary Palm does not have over this state, over the full state. The interpretation I'll come out and say it. In this court's view, it feels that more likely than not, this interpretation ignores the legal reasoning, logic, and very clear statements made by the Wisconsin Supreme Court in the Palm case. Here are some of them. This is going to get long-winded, but I want it on the record. Paragraph 1, and I'm quoting from the Supreme Court on all of these, leaving out some of the internal citations, but these are their words, not mine. Paragraph 1, Supreme Court says, this case is about the assertion of power by one unelected official, Andrea Palm, and her order to all people within Wisconsin to remain in their homes, not to travel, and to close all businesses that she declares are not essential in Emergency Order 28. Paragraph 4, we further conclude that Palm's order confining all people to their homes, forbidding travel, and closing businesses exceeded the statutory authority of Wisconsin Statute Section 252.02, upon which Palm claims to rely. Paragraph 24, we conclude that that Order 28 is a general order of general application. The order regulates all persons in Wisconsin at the time it was issued, and it regulates all who will come into Wisconsin in the future. If we were to read the definition of rule, as Palm suggests, one person, Palm, an unelected official, could create law applicable to all people during the course of COVID-19 and subject people to imprisonment when they disobeyed her order. Paragraph 28, rulemaking exists precisely to ensure that kind of controlling, subjective judgment asserted by one unelected official, Palm, is not imposed in Wisconsin. Paragraph 31, in addition, we employ, I'm going to mute some people here because now I've got you all muted. Okay. All right. Paragraph 31. In addition, we employ the constitutional doubt principle. That is, we disfavor statutory interpretations that unreasonably raise serious constitutional questions about the statute under consideration. Palm points to statutes that she asserts give her broad authority to impose regulation, but it does not follow that she can impose regulation without going through a process to give the people faith in the justness of the regulation. However, under Palm's theory, she can implement all emergency measures necessary to control communicable diseases, Wisconsin Statute Section 252.02 sub 6, even at the expense of fundamental liberties, without rulemaking. That interpretation is constitutionally suspect. We do not construe Section 252.206 as an open-ended grant of police powers to an unconfirmed cabinet secretary. When a grant of legislative power, okay, paragraph 34. When a grant of legislative power is made, there must be procedural safeguards to prevent the arbitrary, unreasonable, or oppressive conduct of the agency. Procedural safeguards, generally, are those requirements imposed by the Administrative Procedures Act, codified at Chapter 227, paragraph 35. Palm cannot point to any procedural safeguards on the power she claims. And then it goes on to say later in that paragraph, rulemaking provides the ascertainable standards to hinder arbitrary or oppressive conduct by an agency. Judicial review does not prevent oppressive conduct from initially occurring. Paragraph 42. Palm asserts, paragraph 42, emergency order 28 is a general order of general application within the meaning of Wisconsin Statute Section 227.01 sub 13. It is a rule, and accordingly, the rulemaking procedures of Wisconsin Statute Section 227.24, which protect people affected by DHS orders, were required to be followed during the promulgation of Order 28. Paragraph 45. Palm asserts her broadest grant of authority is WisStat Section 252.026, sub 6, because it says she can authorize and implement all emergency measures necessary to control communicable diseases. She asserts that all, as a modifier, suggests an expansive meaning because all is a term of great breadth. She argues that she does not have limitless power under this subsection because it applies only in an emergency, and the statute requires an action be necessary. Paragraph 49. However, Order 28 goes far beyond what is authorized in WisStat Section 252.02 sub 4. For example, Order 28 exceeds the Section 252.02 sub 4 authority to quarantine those infected or suspected of being infected. Instead, Palm quarantines all individuals present within the state of Wisconsin by ordering them to stay at home or at their place of residence, with exceptions she deems appropriate. She also prohibits all public and private gatherings of any number of people that are not part of a single household or living unit. Again, this directive is not based on persons infected or suspected of being infected. Paragraph 50. Palm skips over this obvious overreach and contends that the first and second provisions of Wisconsin Statute Section 252.02 sub 4 permit actions taken in Order 28. However, once again, Order 28 is overly broad in its prescriptions. All forms of travel are prohibited, except for essential travel as defined in this order, i.e. by Palm. If this restriction supposedly is connected to the first permissible action under Section 252.02 sub 4 to guard against the introduction of any communicable disease into the state, Order 28 goes well beyond entry of communicable disease into the state. It prevents all forms of travel, not simply interstate travel. Furthermore, nothing in Section 252.02 sub 4 permits Palm to close all for-profit and nonprofit businesses with a facility in Wisconsin, except those Palm defines as essential businesses and operations. She cites no authority for this vast seizure of power. The explicit authority requirement is codified at Wisconsin statute section 227.102M, which provides, quote, no agency may implement or enforce any standard, requirement, or threshold unless that standard, requirement, or threshold is explicitly required or explicitly permitted by statute or by a rule that has been promulgated in accordance with this subchapter. Furthermore, with statute section 227.11, sub 2, sub A, numbers 1 through 3, as summarized by a recent comment in the Wisconsin Law Review, quote, prevents agencies from circumventing this new explicit authority requirement by simply utilizing broad statutes describing the agency's general duties or legislative purpose as a blank check for regulatory authority. The explicit authority requirement is, in effect, a legislatively imposed canon of construction that requires us to narrowly construe imprecise delegations of powers to administrative agencies. In addition, the legislature cites two more canons of construction that it asserts apply here. First, the legislature does not alter fundamental details of a regulatory scheme in vague terms or in ancillary provisions. Second, the legislature cites constitutional doubt principle, as the United States Department of Justice has recently written in a COVID-19 related case raising constitutional issues. Quote, there is no pandemic exception to the fundamental liberties the Constitution safeguards. Indeed, individual rights secured by the Constitution do not disappear during a public health crisis. These individual rights, including the protections in the Bill of Rights made applicable to the states through the 14th Amendment, are always in force and restrain government action. Paragraph 55, we do not define the precise scope of DHS authority under Wisconsin statute section 252.02, sub 3, sub 4, and sub 6, because clearly order 28 went too far. We cannot expansively read statutes with imprecise terminology that purport to delegate lawmaking authority to an administrative agency. The legislature appropriately cites the statutory explicit authority requirement, Wisconsin section 229.102M, and has provided plausible readings of the text. Administrator Bowersox is doing at a local level what the Supreme Court found impermissible at the state level. And she's doing so with powers under Chapter 252 that, if her interpretation is to be believed, are even more powerful than Secretary Palm's powers. This, despite the fact that under Chapter 252, local health officials are subservient to the State Department of Health Services, which has the statutory ability to act in the place of local health officials under WisStat section 252.03 sub 3. Secretary Palm has conceded an oral argument that her power to issue general orders of general application were not limited, that she has those powers, but she failed to say how her powers were limited other than to whatever she believes on whatever given day is reasonable and necessary to control disease. Wisconsin Supreme Court held that Palm didn't have this power to issue general orders of general application to non-sick residents, but Administrator Bowersox is doing just that. She's issuing general orders of general application to non-sick residents under the same chapter statutory scheme. Administrator Bowersox argues that she has the power to do what is reasonable and necessary for the prevention of disease under WisStat section 252.03, sub 1 and sub 2, and to do what's reasonable and necessary for the prevention of communicable disease. She explicitly cites these powers as part of her authority for her May 13th, 2020 order. This power, however, is not limited by an emergency, as there is no mention of an emergency in 252.03 sub 1 or sub 2. If Administrator Bowersox's position is adopted by this court finds it would give her limitless power. What isn't lost on the court is that Administrator Bowersox would have such limitless power even if there was no emergency, and even if there wasn't a communicable disease at issue. She directly cites to her power to do what is reasonable and necessary for the prevention of disease, as I previously stated. COVID-19 is a disease. It's also a communicable disease. Other diseases, as I've stated earlier in this case today, are cancer, heart disease, diabetes, etc. If Administrator Bowersox has a broad authority to shut down Racine because of a disease, then she has the power to shut down all or parts of Racine if she believes it is reasonable or necessary for the prevention of any other disease. That means the power to ban sugary drinks if she believes it will help curb diabetes in our community, a disease, banning deep fried foods at restaurants to cut down on heart disease, alcohol sales, to mitigate liver disease. I could go on, but the point has been made, and the vast power allegedly held by one elected bureaucrat is noted. Would she do these things? Probably not, but who knows? She claims to have the power to do so. With absolutely no procedural safeguards to protect the residents of city of Racine from her vast alleged power. No explicit legislative authority to do so, and no statutory due process relief valves, such as are found in WSStat 252.07 for infectious tuberculosis. If Administrator Bowersox isolates or quarantines a tuberculosis patient, her isolation or quarantine power is limited to 72 hours without a court hearing. After that, she has to get a court order to confine the patient for any longer period of time. If she isolates or quarantines a citizen under WSStat 252.06, the provisions of WIS Admin Code DHS 145.06 kick in. She may issue a directive, and if it is ignored, she can go to court to get her directive enforced. Her reading of her broad and vast powers under WSStat Section 252.03 seems to swallow every other portion of Chapter 252 that applies to her, and renders it all really superfluous. As stated in Palm, courts cannot expansively read statutes with imprecise terminology that purport to delegate lawmaking authority to an administrative agency or an unelected bureaucrat. Nor can a court interpret a statute in such a way that it renders other statutory phrases as surplusage. And that's the case of State v. Matizek, 2014, Wisconsin 27, paragraph 17. In light of the above, the court makes the following specific findings. Mr. Yandel has more than a reasonable probability of success on the merits. Administrator Bowersox's orders are all based upon her perceived general power under WSStat 252.03 as a local health official to issue general orders of general application. There is more than a reasonable probability that this court will ultimately declare that Wisconsin Supreme Court's decision in Wisconsin Legislature v. Palm, 2020 Wisconsin 42, controls this case and is of such persuasive weight that this court is not free to ignore or disregard it just because it doesn't speak directly to a local health official's power under WSStat 252.03. There is more than a reasonable probability that this court will ultimately adopt the reasoning and rationale that the Wisconsin Supreme Court used to interpret the powers of Secretary Palm under Wisconsin Statute 252.02 and apply it to this preliminary and apply it to Administrator Bowersox under 252.03. As such, there is a reasonable probability that this court will ultimately declare that local health officials, such as Administrator Bowersox, do not have the power to issue general orders of general application under WSStat 252.03 or under WIS Admin or under the Wisconsin Administrative Code, DHS Section 145.06. Mr. Yandel has no other adequate remedy at law to stop Administrator Bowersox from exercising general powers under WSStat 252.03 or DHS 145.06 and continue to issue general orders of general application that constrain his ability to run his business. Mr. Yandel is likely to suffer irreparable harm to his business if Administrator Palm continues to exercise general powers under WSStat 252.03 or 145.06 DHS and continues to issue general orders of general application. A temporary injunction in this case is necessary to preserve the status quo of the parties that existed prior to Administrator Bowersox's first exercise of a general power to issue general orders of general application under WSStat 252.03. Based upon the foregoing, it is hereby ordered. Plaintiff's motion for a temporary injunction order is granted. Defendants are temporarily enjoined from enforcing the forward Racine order or enacting any other orders pursuant to Administrator Bowersox's exercise of general powers to issue general orders of general application under Wisconsin Statute 252.03. I note the Attorney General has been served in this case, but the Speaker of the Assembly, the President of the Senate, and the Senate Majority have not yet been served with a copy of the proceeding. Under Wisconsin Statute 80604 sub 11, they have a right to be heard on the declaratory judgment claim before this court rules finally on it, and how this court is going to ultimately declare 252.03. Had they been served, I might have been able to get to the ultimate issue today, but without service on them, I'm not going to. I'm going to give them the opportunity to weigh in if they want. I know that Attorney General call. Attorney General call, not attorney call anymore. Attorney General call was served with the process. He had the right to be heard today. He didn't ask to do so. He may at the final hearing, and that's fine. But the court is going to accept an additional brief. So here's what we're going to do. Plaintiff shall serve the Speaker of the Assembly, the President of the Senate, and the Senate Majority Leader with a copy of the proceedings on or before Monday, June 22nd, 2020. That's this coming Monday. Court's going to accept an additional brief and affidavits from the parties on the declaratory judgment claim on or before Thursday, June 25th, 2020. Court's going to hear oral argument on the declaratory judgment claim next Friday, June 26, 2020 at 1:30 p.m. And the reason I'm docketing this is because one or both of you are going to want to appeal. The way it looks now, it's probably going to be the city, but I want to get them into the appellate courts. And if they think I'm wrong, then I want them to have as quick a relief valve as possible into this process. And so that's why we're going to be moving quickly on this. And that's why I'm rushing you a bit on these issues, but let's be honest. I mean, you guys have argued 25203 already now for an hour here. I can't imagine there's much more to say, but if I get it, I will read it and consider it. And I may very well at the end not declare it if it's convincing to me. And I'm going to leave that open. I'm not foreclosing that ability. I'll sign an order to this effect today, goes into effect immediately. We're going to go off the record, and that order will be uploaded into CCAP in about an hour. Good luck to all of you, and thank you for the wonderful argument, the good lawyering. I really appreciate it, and good luck to everyone. Going off the record.
Thanks.
Yes.
Thanks, Judge.
For the record, Your Honor, I just need to ask you to stay your order pending our ability to appeal.
Yes, I was going to mention that, and I expected that. I'm sorry, I didn't mean to cut you off from that. The request to stay is denied, but it is noted on the record now. Thank you.